I'm happy to venture a guess, but there's a public record of this. I want to say it was 2 to 3 weeks we were given to write our brief, but trust the record instead of my memory on that.
And so the brief was filed right at the beginning of October, I think, or the end of September?
Whatever the record shows.
And the election was just weeks away, correct?
The election was November 3rd?
Yes.
Yep.
Did you have any communications amongst your staff that this presented potentially a problem with the Justice Department's election year sensitivities guidelines?
So when we got the immunity decision, we had a series of decisions to make. The first was to look at our evidence and see, do we still have a case here? Do we still have admissible evidence that would allow us to proceed to trial? So that's what we did first. Once we determined that we did have that evidence, the next thing we determined is, do we need to supersede the indictment? And because there was evidence before the grand jury that the Supreme Court had clearly said was immune, we determined that we needed to supersede the indictment. And I'm sorry I'm being long, but I think the context will help. Once we determined that, we had to make sure that our conduct in going forward with an indictment and everything after complied with the election year sensitivities policy. And to do that, we consulted with public integrity on drafts of the indictment, on our plan forward, and as we set forth in the final report, Ping concurred that we had complied with that policy. And I would just add that policy does not stop prosecutors from trying their cases in court.
Okay. Did you or anyone in your office discuss the potential political or electoral impact of publicly filing that amount of information, just with the election a month out?
My focus was on making sure we complied with the election year sensitivities policy, which is the way the department addresses those issues.
Okay. And so, I mean, the whole purpose behind the policy is not to interfere with elections, right?
Correct.
And so the way the policy is written, I guess, is that as long as you have filed your case and as long as you're already in court, then there's no limitations on the types of court filings you can make. Is that right?
Well, I will say, and as you know, I was the chief of public integrity. Historically, I don't recall any cases where it ever applied to anything. It was really about investigative stage steps, doing a search warrant or taking investigative steps before an election. But this is one of those issues where this is why you consult with public integrity, because they're now the keepers of that policy. Right. And so we consulted with them about the path we took, and they agreed that what we ended up doing did comply with the rules.
I mean, after you left public integrity, there was a February 2020 memo from Attorney General Barr and Attorney General Garland, in effect re-upped Barr's memo with his own election sensitivities memo. I think he incorporated it by reference, in fact. And this is against the backdrop that a lot of what happened during the 2016 election caused a lot of concern that what happened at FBI, what happened with both the Crossfire Hurricane investigation and the mid-year exam investigation, may have affected the outcome of the 2016 election, correct?
I'm not saying that's wrong. I'm not sure I followed that closely.
Okay. You're aware of the concerns of the Justice Department, in the fallout of the Crossfire Hurricane investigation.
I don't think the election year sensitivities policy was born out of that. I think it's existed for a long time and in kind of the same format for a long time. And I know the last person to sort of restate it was Attorney General Garland, who I think did it shortly before I was appointed, if my recollection is correct.
But he incorporated by reference, Attorney General Barr's memo from 2020. And Attorney General Barr, his memo was in the fallout. It was in the wake of everything that happened with the Steele dossier, what happened with Crossfire Hurricane, and so forth. And so the question is, your 165-page brief a month out from the election. It seems from an outsider's perspective that runs the risk of, impacting the outcome of the election.
Yeah, we certainly were not in any way intending to affect the outcome of the election. And to make sure we complied with the policy, we met with Public Integrity to make sure we were doing that. They agreed, and they're the ones who enforced that policy. And so I felt comfortable taking the course that we did going forward.
Did your office ever consider some of the things that happened to President Trump, in the 2016 election with the Steele dossier, with using the Steele dossier to get FISA warrants? Did you ever discuss any of that as background, that we need to be careful here with President Trump, that we don't repeat some of the things the Justice Department went afoul of in 2016?
I don't recall ever discussing the Steele dossier or anything like that with my staff. I don't recall that.
And I know Justice Department officials often like to say that, hey, everyone at the Justice Department is nonpartisan, apolitical, they check their politics at the door. And I think you would say that is the case with everybody on your team, correct?
I would say that has been my experience in the Justice Department through both Democratic and Republican administrations. I've worked in the department through both, and that has been my experience.
And we learned in the fallout of the 2016, the events of the 2016 timeframe, that there's Peter Strzok and Lisa Page, and I think we can all agree they were not apolitical and nonpartisan. They were very clearly, as their text message traffic bears out, they were very interested in preventing President Trump from becoming president. Is that something that you were aware of?
I was aware factually of that,
Right.
yes.
And can you agree that, as the text message traffic bears out, those two officials were not, nonpartisan and apolitical?
Well, I certainly agreed with Director Mueller's choice to move them off the team once he discovered those, absolutely.
And did you ever have any discussions with your senior management to make sure that your team wasn't infected by any of those types of issues?
Yes, I did.
Okay. And can you tell us about that?
So I made it clear from the day that I began at the Special Counsel's office, this was going to be a nonpartisan investigation. This was not, the politics would play no role in it. I think everybody in my office agreed to that. I can tell you of one incident where we were reviewing the email chains of agents who might be witnesses in the case for Jiggly review. And we needed them to give us all their emails. An FBI agent who was working on the case took that direction and actually provided us with his private emails with his family. We didn't ask for that, but he gave us his private emails. In one of those emails, and I can't remember if I saw this or my deputies saw this, he was having a dispute with family members where it was about January 6th. Once I saw that or heard about that, I decided he could no longer work on this investigation. And I think that was consistent with how I ran the office. And I want to also be clear, I never saw that agent do anything that I considered partisan. But just to make 100% clear to my staff, and this is an agent who volunteered this beyond what was required. I wanted to make it very clear that anything like that was not going to be part of our investigation.
The 165-page brief that you filed at the beginning of October, was there any consideration of maybe filing it under seal, at least until the election was over?
Well,
obviously you have to go to the court and all parties would have to agree, but certainly if all parties agreed, the judge would be amenable.
I feel like this came up in the status conference that we had. I can't recall. What I can recall, though, now that you're reminding me, is there was an issue, and this is referenced in our final report, where we filed our brief. They were given time to file their brief. They wanted more time, which would put their brief after the election. We had our exhibits, which were really the evidence, that we were citing. That evidence, they made a motion that evidence, the key facts, should be filed under seal. And they, before filing their motion, usually the practice is to ask opposing counsel, what's your position about this? But they filed their motion before they could get our position, and so we contacted the court, and we said that we had no objection to that evidence being filed under seal if the court agreed. Now, the court ultimately did not agree, and so this is referenced in a footnote in our report. I think that that is pretty direct evidence that we were not seeking to put the maximum amount of facts in the public record, that we were happy to have that be under seal, and even after the election, if that's what the court agreed.
Okay, but you could have sought permission to file that big brief under seal, right?
I suppose we could have, and again, this is where my memory is escaping me. I feel like this issue was possibly discussed with the court, and I think the record of what any briefing on this or what the court said will be better than my memory about this.
Okay. Did you think it was important that that evidence be in the public realm before the election? So, people could make up their mind about who they were going to vote for?
No, I did not see it as our role to provide evidence for people to make their voting decisions on. Yeah, if I could, the final report on page 107, footnote 258. On the 17th of October, Mr. Trump filed a motion to delay public disclosure of our appendix to the brief, meaning the actual evidence.
Sorry, say that page again?
Yeah, sure. It's 107. I'll let you get to it. 107, footnote 258. They filed a motion to delay the appendix, meaning the evidence, until after he filed his own appendix, which would have been November 14th, well after the election.
Yeah.
So that both appendices will be released simultaneously after the election. He filed that motion before obtaining our position, so we emailed the court's chambers, copying defense, informing the court that we did not object to that procedure, meaning we did not object to our evidence being, in essence, embargoed from the public until after the election. So I think that's pretty strong evidence that we were not trying to have an effect.
Notwithstanding the fact that it's a 165-page brief that you said.
It was.
And that's, in my understanding, that's, first of all, you choose to do it, 165 pages. I think it's 4 times the size of your normal briefs that are supposed to happen with these type of motions. And I believe the judge said this was not typical. Is that right?
Yes, but
Judge Juckins said it was not typical.
she used a word like that, but I would just say when you say these type of motions, I think filing a brief after an immunity decision is not a common issue, and having to have a new evidentiary issue added to the mix in addition to the immunity issue, I don't think this is.
Is there any new evidence in the 165-page brief?
I'm sure there was, but as I said, my recollection is the majority of the evidence was already public. The brief emphasized how we could prove our case using evidence of his role as a candidate, as opposed to evidence that might otherwise be precluded by the official act. So, for example, a thing in the brief would be that at least 2 of the White House staff members who would have been witnesses, that they also were also working on the campaign. And so not a particularly important fact in the world, but important for our particular brief. So there were facts like that and others that were new that were in the brief.
I just want to summarize that you